Tēnā koutou, tēnā koutou, tēnā koutou katoa. My name is Joanna Mossop. I'm an associate professor at the law faculty here at Te Herenga Waka, Victoria University of Wellington. And it is really my great pleasure to welcome you here today to this panel discussion on legal issues affecting the future of the South China Sea. I want to express my thanks to you for attending and also to our panelists for joining us from around the region. This is the culmination of a two-day event which has been co-hosted by Victoria University and the Embassy of Japan in New Zealand. What we're going to be doing this afternoon or this evening, depending on where you're at, is we have three of these eminent experts here joining us from Japan, the Philippines, and Australia. Now, normally in usual circumstances, we would welcome them here in Wellington in person, but obviously we are now living in the COVID age and Zoom is the new normal. So hopefully the technology gods will smile upon us and our discussion will be smooth and uninterrupted. Rather than asking our panelists to make a formal presentation today, we thought that it would be very interesting and enjoyable to actually have a conversation among these experts. So I have prepared some questions and I'm going to hopefully facilitate a discussion. We hope to have time for questions at the end, so keep that in mind. And I also want to remind you that at the end of this event, we have a reception that is going to be held on the mezzanine level. So we invite you to join us at that. Sorry to the speakers that you can't join us for that part of the occasion. So without further ado, I'd like to introduce our speakers. Professor Kentaro Nishimoto is a professor of international law at the School of Law, Tohoku University, and the Arctic Environment Research Centre at the National Institute of Polar Research. His research focuses on the law of the sea, including issues such as the history of the law of the sea, sustainable development of ocean resources, Arctic issues, and the settlement of maritime disputes. So welcome, Professor Nishimoto. Dr. Lowell Bautista is a senior lecturer and head of postgraduate studies at the School of Law and the Australian National Centre for Ocean Resources and Security, ANCORS, at the University of Wollongong. Dr. Bautista is recognised for his expertise in the law of the sea, particularly for his contributions in the area of territorial and maritime disputes in the Asia Pacific and especially the South China Sea. So welcome, Dr. Bautista. Professor J. Batongbacal is an Executive Associate Dean at the University of the Philippines College of Law. He has a master's and a doctorate from Dalhousie University in Canada, and he has advised the Philippines government on a number of issues, including on their submission to the Commission for the Limits of the Continental Shelf for a continental shelf beyond 200 nautical miles in the Benham Rise region, and for the designation of a natural park as a particularly sensitive sea area by the International Maritime Organization. So welcome to you as well. Okay, so let's start. My first question is one for all of the panelists. So 5 years ago, the South China Sea case had the arbitral tribunal in that case issued its decision on the merits in the dispute between the Philippines and China in relation to the South China Sea. China, of course, didn't appear in that case, but the tribunal found overwhelmingly in favour of the Philippines in that case. So I would like to ask each of you what you think has been the overall impact of the South China Sea arbitral award on the disputes in the South China Sea. And perhaps we could start with Professor Nishimoto.
Thank you very much. I hope you can hear me well. And first of all, thank you very much for having me on this panel. It's really unfortunate that I missed probably my first opportunity to visit New Zealand, but perhaps there'll be other occasions. So with regard to the very important issue, I think an impact of the South China Sea arbitral award is that it has changed how the dispute is viewed from the perspective of international law. And one visible consequence of this change within the overall dynamic in the South China Sea is the shift in the attitude of states from outside the region. And interestingly, a number of states from outside the region sent notes to the Commission on the Limits of the Continental Shelf last year in response to China's diplomatic notes objecting to the submission by Malaysia to the Commission. And the number of states were United States, Australia, France, Germany, United Kingdom, and also Japan. And they have made clear statements expressing their legal positions, some of them which explicitly cited the arbitral award and the determination in the award that China does not have historic rights in the South China Sea. And of course, even before the award, China's claims to historic rights was viewed unfavorably by international waters and states. But there were other uncertainties, such as whether you can draw straight baselines around the archipelagos, whether the islands in the South China Sea can generate EEZ and continental shelves. So there were different possible scenarios with different levels of plausibility in terms of the interpretation of the relevant rules of UNCLOS. But the award provided a very clear answer to the entitlement of states in the South China Sea, which is binding on the states parties to the arbitration. And as such, other states expect the parties to comply with it. And now the issue is no longer about taking sides in a bilateral or multilateral dispute, but expecting the parties to act in accordance with international law. And of course, it could still be asked whether this development is really helpful to the resolution of the overall situation. And China has responded to these notes using very strong language, saying that it opposes using UNCLOS as a political tool to attack other countries. However, I don't think this is how this situation should be viewed. And I think the concerns about the rule of law at sea is a very real one from all of the states that have sent notes to the COCS. And at the risk of sounding like a naive academic, maybe placing too much confidence on international law, I think the only way to an acceptable resolution of the overall dispute between all of the relevant parties would seem to be one based on international law. So the award may not be able to directly change Chinese policy or the position of China so far on the South China Sea. But given the circumstances, it really seems likely that we would have found ourselves in the same or even worse position without the arbitral award. So in conclusion, I would view the award as having a very positive influence, even if it has not translated into concrete progress towards the resolution of the overall dispute. So that will be my take on your question. Thank you very much.
Thank you. Jay, you are based in the Philippines, so of course you've got a particular interest in the impact of this award. What's your view on this? Your microphone is muted. You'll just need to...
Well, I agree, of course, with what Nishimoto-san has already explained very well. No? It is, I think, overall a positive development, even though we still have problems arising from the overall attitude and posture of China. But one thing we should also remember is that the South China disputes is not only with respect to China, the Southeast Asian countries themselves also have disputes with each other. So at least the literal Southeast Asian states' official recognition of the South China Sea Arbitration Award as being the proper template for allocating coastal state jurisdiction in the South China Sea, that lays the basis for the smaller claimants now to resolve their disputes between themselves. And in a way, also, this seems to act as a kind of dispute prevention mechanism between them. The alignment of their maritime claims with UNCLOS has reduced, therefore, the probability of disputes between them, between the smaller Southeast Asian states, no? Because they've all committed to keep within the bounds of their respective jurisdictions under UNCLOS. In that sense, the award has moved at least some part of these disputes closer to resolution, no? The part which deals with the smaller claimants' claims against each other. Now, the rejection of China's claim, symbolized by its 2009 dash lines, has actually been far clearer and more pointed now. This has not only, as noted, it's not only just the Southeast Asian states, but also external states with interests in access and to or through the region. As mentioned, these were even expressed very clearly in various diplomatic notes. Now, On the other hand, despite in spite of insisting on the invalidity and irrelevance of the award, China nonetheless has been constrained to de-emphasize and move away from its original formulation of its claim being unacceptable and too ambiguous. No, these 9-dash lines and historic rights claims, we have seen a clear shift, no, in its emphasis. In a way, it's changing its discursive strategy and diplomatic posturing toward what it hopes to be a more plausible theory. No, but now it's often referred to as the four-sha theory, which we can probably discuss later. But while this theory still remains problematic for other reasons, the fact that China shifted its legal strategy and diplomatic posturing is clearly attributable to the South China Sea Arbitration Award and is indicative of its need to attain some kind of legitimacy and recognition on the basis of a legal framework. This adjustment towards a more familiar and transparent, shall we say, UNCLOS-based framework is a slight improvement at least, but it indicates that China is well aware that it cannot push its historic rights-based claims very far anymore in the absence of evidence and substantive content, and in the absence of clear support from international law. So much less would it be able to gain any acceptance or recognition from other affected states. So in that sense, again, it at least reduces the avenues by which these disputes could potentially expand in the future. So I think that's what I can say for now.
Thank you, Professor. Yeah, that's very insightful. Dr. Bautista, do you have any observations to make?
Thanks, Joanna. Greetings from Sydney and good evening to the participants in New Zealand. Before I begin, I'd like to express also and echo my sincerest appreciation to the organizers of this workshop. I consider it a privilege and an honor to share my thoughts with all of you this evening. It's difficult to speak last because I feel that I have very little to add. But when I was thinking of what to say for this panel, I was actually reminded of a statement attributed to Marcus Aurelius, who said very thoughtfully, everything we see is perspective, not the truth. And really, this is true. It's a matter of perspective. And I think it's very sound advice and one which is full of wisdom. And personally and professionally, it took me an entire lifetime to learn and apply this lesson. And when we think of the South China Sea disputes, we probably have very negative ideas of the matter. And as Professor Nishimoto said, the issue is very complex. It's complicated. There are a variety of ways of looking at the issue. You can look at it from the perspective of international law, from international relations, diplomacy, security, history, politics. But I think if I may offer, I think it's good to look at it from the perspective of the claimant states, because as you can appreciate, the narratives, the drivers, the strategic imperatives, the domestic laws and policies behind the claimant states will be very different from each other. Also, you can look at it from the perspective of the non-claimant states or the other literal states. And we see this tension within ASEAN, for example, which has members who are non-claimant states, Cambodia, Myanmar, Laos. And also you can look at it from extra-regional states and powerful maritime states, such as the US, Australia, India, even countries in the other parts of the globe, such as the UK, France, members of the EU, and finally, the international community at large. So I think framing is very important. It's a matter of perspective. Anyway, going back to the question, I believe the general question propounded to the panel calls for an evaluation or an assessment. But how does one assess or evaluate the South China Sea Arbitral Award? Of course, textually, if you look at the award, the final award represents an overwhelming legal and moral victory for the Philippines. The tribunal unanimously decided in favor of the Philippines. It declared the 9-line as no basis. But 5 years since then, the South China Sea situation remains unresolved. So we don't know who owns the features. There's still overlapping maritime claims. And if you look at how the analysis has been going, traditionally, the effectiveness of international courts has been measured by whether their decision has been complied with. So it's unsurprising that when you look at the arbitral tribunal, it has been derided because of China's non-compliance. But in my opinion and in my analysis, I completely disagree with this proposition. In my opinion, the impact of the South China Sea Arbitral Award has been positive. As Jay and Professor Nishimoto already mentioned, There's been greater clarity in the disputes. It's been narrowed down. You can see from the reaction from the littoral states and beyond. There's been widespread support. There's been statements of support and diplomatic notes from Brunei, Malaysia, Vietnam, Indonesia, Australia, the United States, even a note verbal from France, Germany, and the United Kingdom. So it's largely positive. But of course, going back to the original question, it still remains it remains unresolved. But that the tribunal has clarified a lot of things at the obligation parties, especially the Philippines and China, which facilitated further relations. And these findings, have an impact on policy considerations as well as how the states behave. So it's really a landmark and important legal decision.
Thank you. It's sometimes been observed to me that in order to be an international lawyer, you have to be something of an optimist. And the three of you have put a very positive spin on the outcomes from this case. Do any of you want to chime in with what you think might be negative impacts from the case, if any? Nope, I've stumped you.
I think the negative impacts, if I may answer that, Joanna, is that there are facts which are which on the ground. I mean, we see. For instance, I can only think of the illegal structures. They remain there. I mean, regardless of the tribunals, the victor of the Philippines, we cannot address, very difficult questions of how to dismantle them, how to ask for reparation, how to address the irreparable damage to the marine environment. I mean, it seems like a hollow victory in that sense because we have, as they say, a piece of paper which is unenforceable, quote unquote. So, I mean, as I said, perspective and framing is very important. So that could be, a negative aspect of looking at this award.
Okay.
Well,
the other two, did you want to say something?
Yes, if I may. Okay, putting on my pessimist hat. If there's a negative, it would be the fact that China dug in even deeper on its claims. And because of that, it imparted a kind of sense of urgency on the part of China to try to resolve the issue coercively. The artificial islands is the best example. Instead of acting fairly and trying to argue its way through the arbitral tribunal, instead it only prompted it to undertake unilateral actions which prevent the dispute essentially from being settled fairly. And now, because of that, they're just pursuing, they're pursuing the logic of that first step of trying to now establish de facto control over the South China Sea, regardless of the law. So in a way, it provided an opportunity for China to essentially challenge the rule of law in this particular region. So that's not as pessimistic as I can get.
Thank you. Nishimoto-san, do you have?
Maybe from a sort of a general international law perspective, I think one of the negative effect of the situation that we have is that the situation is really difficult to understand for people not acquainted with international dispute resolution. So to some extent, we need to explain why this award is not being complied with. And maybe people who are unacquainted with international relations or international law might think, well, this system is not really working well. But I don't think that is the case. We do have, of course, issues with how the award and judgments and awards from international courts and tribunals are complied with and maybe not complied with in certain cases. But as we have been discussing, it does work in its own way. But as we had to sort of discuss this issue as the starting point for our discussion today, it is somewhat difficult to understand, and it could sort of be seen as the ordinary people who are not acquainted with these issues as sort of situation that we have where we have sort of a difficulty going forward with this process. So that would be my comment on that.
Thank you to all of you. Dr. Bautista, since you went last time, shall I ask you a question first this time? So in recent years, attention has been focused on China's use of the so-called maritime militia and its apparent role in asserting China's claims in the South China Sea. From your perspective, how should the affected states properly respond to the activities of this maritime militia?
In my honest opinion, Joanna, I think how the state should behave is, one of indignation, or they should treat it as being provocative, because you should understand. We should understand that China is using some sort of legal ambiguity to take advantage of pursuing a gray zone conflict in the South China Sea to pursue its strategic objectives. They're using non-traditional actors and actors which have ambiguous legal status. It would be easy if it were, a Coast Guard vessel or a PLA vessel. But when you look at the nature so there are two things we should look at. The nature of these vessels, the location of where these activities are happening. So when you look at the nature of these vessels, it's ambiguous, because the use of force against a naval auxiliary is more contentious. But if it's a rogue vessel, it would be simply law enforcement. So you can see how China is actually taking advantage of this legal ambiguity to actually, as Jay already hinted at, to change the facts on the ground, to have a de facto or physical occupation or administrative control or jurisdiction over areas which are not supposed to be disputed. So I think, looking at it from a bigger perspective, I think this is really China's grand strategy to again to have a fait accompli, and then later on change the facts so that the disputes are not just made more complicated; they're made irreversibly, irreversible. So I think the reaction should be one of indignation and one of you should treat them as really very provocative, and something that is non-benign. That's my opinion.
Okay, thank you. Professor Batongbacal?
Yes. Well, the People's Armed Forces Maritime Militia, no? That's their official title. It has become the vanguard of China's maritime assertions in the South China Sea, and they're deliberately employed and used to avoid eliciting a defensive response while purporting to be some kind of non-invasive civilian use or presence. No? But President Xi himself entrusted the maritime militia with the role of asserting and expanding China's influence and control of areas in the South China Sea, particularly the Spratlys, and even perhaps in opening up new frontiers of dispute, such as Indonesian waters, based on what's been happening in the past couple of years. This really turns on its head the principle that the basic principle that fishing cannot be the basis of sovereign claims, and it makes it appear that civilian fishermen can act as representatives of the state, no? And so the use of the maritime militia, as noted, falls within the scope of the so-called gray zone operations, and is part and parcel of that broader effort to establish de facto administration and control of this large area. Now, earlier during the conference, we had Stuart's excellent presentation on the operations of this group, and it really also shines a light on the role that the maritime militia has played in many incidents in the South China Sea, and their potential connection and attributability to China under the Articles on State Responsibility. But because of this ambiguity, these connections are a little bit hard to be made. No? Now, recently, the incident on Whitsun Reef is a very good example of how the militia operates and how gray zone operations manage to exploit these gray areas of the law. And it causes hesitation on the part of the affected states. No? They hesitate in making any national responses. No? So we can see that the militia operations work because of their, number one, physical isolation at sea. Second, the salami slicing of even legal questions and issues into finely separated points, no? So that you can take advantage of the ambiguities or the loopholes in one particular issue. And lastly, we see China's ability to seize and shape the narrative that follows from such activities. So I think that the proper counter to such activities basically involves removing the ambiguity, no? And this can be done in the following steps. Now, first of all, we have to appreciate the role and contribution of the maritime militia in the broader strategy to take the South China Sea without a fight, no? So, for example, at Whitsun Reef, it's not only anchoring but it's anchoring as part of a broader process, a larger process of de facto occupation and control, lacking only one more element, and that's the active exclusion of everyone else. No? The second step would be to declare and attribute the actions of the maritime militia openly and officially to China, and presume that such activities are not civilian activities, despite their civilian trappings. No? And they should be considered as extensions of government actions to assert and establish a control of the South China Sea. No? And in a way, that's the presumption. They have to prove the verse. No? Third, we need to expose these operations and establish transparency and immediate and uninterrupted communication and surveillance of areas where they are operating. This is to prevent the militia from making headway in the legal and public discourse on which it relies in order to make governments hesitate, no, in taking responsive measures. And next, we should reject any potential legal impact or implications of such operations. They are basically operations or actions in bad faith. No? And would be the way to recover or defend the legal or public status quo. And next, we should then consider measures to disperse or peacefully expel the militia from their areas of operation. And here, everything from diplomatic noise to perhaps confrontation, as done by Vietnam, no, should be on the table, depending on the situation. So those are the things I think which should be done in order to remove these ambiguities that they've been taking advantage of. And so each country should basically formulate a specific policy on the operations of the maritime militia, so that they will know what to do next, the next time it is being employed.
Thank you. That's a great answer. Nishimoto-san.
Well, I don't have much to contribute to the very excellent and detailed comments, but I just want to express my complete agreement with the observation that China is exploiting the ambiguity of the status of the maritime militia, and that this is creating a very much difficult legal and practical issue in responding to the activities. And in terms of the legal issues, we have the issue of attribution in the context of state responsibility, which was addressed in the earlier comment. And there is also the issue of distinction in the case of an armed conflict, although I am hoping that it doesn't come down to that in the end. Thank you.
Of course. Thank you. Well, since you just went last, Nishimoto-san, I'll address my next question to you. So over the years, China has tried to rely on sources of law other than UNCLOS to justify its claims in the South China Sea. And most recently, we're hearing arguments from China that we need to improve UNCLOS. What do you think is the future of such legal claims?
Okay, thank you for that question. And I think it's a relatively and very new, interesting development, which seems to reflect the need felt on the part of China to justify its position in the South China Sea. And I think this aspect was sort of covered under the discussion by Professor Batongbacal in his earlier comments. So I think there is a need felt on the part of China to justify its claims in response to the arbitral award. And I think this is one way in which that justification is attempted. The original historic rights claim within the 9-dash lines, in itself was a claim to justify claims by pointing to rights external to UNCLOS. But the arbitral award denied such a possibility. So now there seems to be a more general reliance on international law other than UNCLOS. And in China's diplomatic notes, responding to the notes by France, Germany, and UK last year, China stated that UNCLOS does not cover everything about the maritime order. And it pointed to the preamble of UNCLOS, which states that matters not regulated by this convention continue to be governed by the rules and principles of general international law. And also very interestingly, the same note contains the statement that China is a firm supporter of UNCLOS and an active participant in the process of developing and improving UNCLOS. And in this context, very interestingly, China referred to the ongoing BBNJ process actually, and the same kind of statements have been repeated also in other international fora. I don't think these lines of argument are persuasive, at least in the context of the South China Sea. And yes, of course, general international law or customary international law applies to matters not regulated by UNCLOS. That in itself is true, and it's very clear. But if there are relevant rules contained in UNCLOS, then those apply between the parties. So we look at UNCLOS first when we discuss treaty-based issues. And actually, a similar kind of argument was made in the Jadhav case between India and Pakistan before the ICJ, in which Pakistan relied on a similar paragraph in the preamble of the Vienna Convention on Consular Relations. And the argument was that rules of customary international law governed the matter that was in question. But the ICJ simply considered that a rule in the Vienna Convention applied to the issue, and therefore there was no role for rules of customary international law, at least on that issue. So the question does boil down to what is provided under UNCLOS. And historic rights is one area where customary international law has a very big role to play, but the arbitral award settled that question, at least in the context of the South China Sea. Generally speaking, there may be other areas where customary international law plays an important role in the law of the sea. However, in the context of the South China Sea, in the present context, I think it's really doubtful whether China can find persuasive justification in that direction. And as for the development and improvement of UNCLOS, yes, the UNCLOS regime has developed over time. And there continues to be work that needs to be done in this area. And there is often reference to the UNCLOS as a living instrument. However, such work is usually about filling gaps rather than altering the basic rules on maritime entitlements. And such work requires efforts to be undertaken collectively among the parties to UNCLOS. So overall, where this line of argument is heading is somewhat alarming, at least to me, since the emphasis on general international law seems to be in the direction of relativizing the role of UNCLOS in the law of the sea. And the idea of developing and improving UNCLOS, although it is sort of framed in very nice words, when we look at the reference to this, especially in the context of the South China Sea, it does seem to reflect the unwillingness to accept the current legal framework and the desire to shape the existing rules in favor of the position of China. So I think it is really of concern in that respect.
Okay, thank you. Really great comments there. Dr. Bautista, do you have anything to add to that?
Thanks, Joanna. I completely agree with Professor Nishimoto. I think, again, we should look at the South China Sea Arbitral Award. And if you look at the award, this question was directly addressed and placed fairly before it, whether China's historic right claims in the South China Sea are in accordance with the rules of international law. And the Arbitral Tribunal unequivocally responded to this question in the negative. China's historic rights claim contravenes the practice of the majority of states. It represents a brazen violation of existing international conventions, which China, of course, does not even deny, particularly in respect to its commitments when it signed and ratified the convention. If you look at the Arbitral Tribunal's pronouncement, it says that China's historic rights are invalid and without foundation in international law, it's only strictly binding between the Philippines and China. However, it will be reasonable to argue by logical extension that China's historic rights in the South China Sea, or what it claims to be historic rights, are ipso jure illegal and invalid ergo omnes. This is my position. The China's position is unsupported, de lege lata, and difficult to imagine de lege ferenda. The Arbitral Tribunal's denial of any historical rights over the South China Sea is not really a denial of their opposability vis-a-vis the Philippines, but it's actually a complete denial of their effect ergo omnes. Claims of historic title are effectively restrictions on the rights of the international community in those waters. And these claims constitute a derogation from general international law. In order for such exceptional claims to succeed and be recognized, the state claiming the derogation, China in this case, needs to have exercised the necessary jurisdiction over them for a long period of time without opposition from other states. This is clearly not the case in the waters claimed by China. If you look at the China's claims to historic waters within the 9-line specifically, it does not satisfy the requirements for historic rights under general international law. Because under general international law, in order for historic rights to be established, 3 elements need to be satisfied. first, the state needs to exercise open, notorious, and effective authority over the area where it claims historic rights. Second, the authority exercise should be continuous and for a long period of time. And finally, other states should have either acquiesced or failed to oppose those rights. And China does not satisfy any of these requirements. China never exercised continuous, uninterrupted, unopposed, let alone exclusive authority over the area enclosed by the Nandash Line. And the littoral states, if you look at their practice, their statements, the other states never acquiesced or recognized China's historic rights claim over the same area. And in fact, the opposite is true. China's historic rights claim has been widely criticized and denounced by the relevant neutral states, as well as the major maritime states. So, I mean, just to conclude, before the Arbitral Tribunal Award, we usually hear China say it has undeniable, undisputable sovereignty over these bodies of water. After the Arbitral Tribunal Award, we should no longer entertain that. And I'm speaking quite boldly and brazenly tonight. But that's exactly how I feel, because I heard some diplomats from the region, they say we should have a coalition of states plus a legitimacy denial, because we should deny claims which are illegitimate. Some of the claims are disputed or disputable. Some are clearly invalid or without legal basis. You should be bold enough, I mean, we meaning the literal states, the claimant states, and the international community at large, to have a position of legitimacy denial. If it's illegitimate without legal basis or already settled, then we should deny the false claims upon which they stand, because that's how the rule of law and this dispute should be treated.
Okay, thank you for that. That's a very impassioned response to that question. Professor Batongbacal, but isn't it legitimate that states, are constantly looking, if you've got a living document, then you might want to sort of try and encourage, directions that you're, within your state interests? I mean, isn't that sort of what every state does?
Well, of course, that is what every state tries to do, but not to the extent of actually undermining the very rules that they are supposed to be subscribing to. In this case, particularly with respect to China and what is emerging to be an attempt to recast the claims in terms more attuned to UNCLOS by using this so-called fourth shell theory, which posits that the island groups in the South China Sea form archipelagos around which you can draw baselines and generate maritime zones. This is a theory that was squarely addressed already by the Arbitral Tribunal in paragraphs 573 to 576. In fact, it considered the argument that this practice might be considered as one unit, as one archipelago, but it rejected it because doing so would essentially render the text of UNCLOS, particularly Article 7 and 47, meaningless. So clearly these types of efforts are not to be looked upon favorably. Second, if at all this kind of effort to recast it through this fourth theory were to be made formally, it would be rejected already. I think that it's a non-starter because it already has been rejected by the tribunal. It's also been clearly rejected by the various external powers and South China Sea claimants who issued their note verbals rejecting this position. And so even now, we can already say that it will never gain acceptance as general international law, as China claims. And lastly, I mean, any attempt to do so at this point would be a self-serving act that is potentially in bad faith, because the existence of the maritime disputes in the South China Sea is already well known, and no one can deny that it has already crystallized by now, and especially after the South China Sea Arbitration Award. So any action like this would be a kind of escalation of the disputes that can be seen as aggravating them or making them more difficult to resolve, especially after the award. No? And given that China was actually given all the opportunities to argue this position, and afterwards it was still rejected. No? And also, undoubtedly, it will be seen as an unreasonable and excessive attempt to enclose large areas of the open seas within internal waters. It will definitely garner objections from many states that use the South China Sea as for their maritime trade.
Thank you very much. I'm conscious of the time passing by, but before we go to the audience, I'd perhaps just like you to respond briefly to one last question. And this is really about the negotiations for the ASEAN-China Code of Conduct, and whether or not there are prospects that this could be an effective instrument for managing future or the current South China Sea disputes. And I'll go to you, Professor Batongbacal, first.
Okay, this is probably where I put my pessimist hat on again, because the idea of the COC is rooted in the 1992 ASEAN Declaration on the South China Sea between the 5 original ASEAN member claimant states. And between them at the time, there was the principle of self-restraint, and peaceful dispute settlement was held very high. And in many respects, it was an extension of the so-called ASEAN way, that relied on good faith, self-restraint, non-intervention, and peaceful discussions in a fair, working towards a fair and equitable resolution, where states would deal with each other as equals. And these principles were reiterated in the 2002 Declaration of Conduct of Parties in the South China Sea, although it also added a more specific commitment to refrain from inhabiting uninhabited rocks and features. But afterwards, China broke its commitments to the 1992 ASEAN Declaration when it installed 6 small huts to occupy mischief reef. And then in 1999, it again enhanced those facilities into a full-blown building. So that was the reason why the DOC came about. It was an effort to try to establish commitments to restraint. But now, 2 decades have passed, and Mischief Reef is a full-fledged military air and naval base, possibly the largest artificial island in the world, and it's only one part of a network of military bases that could potentially take control of the South China Sea by force. And even without armed conflict, those bases are now being used by China to establish continuous presence and conduct unilateral activities in the EEZs and continental shelves of other littoral states, as part of its broader strategy to establish de facto control and administration. So the point here is that the idea of the COC probably needs to be re-examined now under this different situation. When it was originally conceived, all claimants had the same basic posture and position in the contested region: small outposts far from the mainland, activities that pose no threat or interference to anyone, except for maybe the occasional incident, but when somebody came too close to one of the features, but nothing serious. And none of them were in a position to force or coerce anyone else with the minimal amount of armed forces that they had deployed in the area. And now China is establishing itself as a dominant power and user of the South China Sea, both in military and civilian terms, and it continues to do so regardless of the legal restraints agreed upon in UNCLOS. The prospect of it being a fair and equitable deal now seems to be rather different from what was originally expected. And one may now consider the possibility that the COC, negotiated under these conditions, might instead result in a legitimization of positions and relations of dominance and subservience in the maritime arena of the South China Sea. So unless it's carefully and judiciously crafted, it may have the effect of creating regional international law that is an exception to the hard-won rules under UNCLOS, and it will upset the hard-won balance of coastal and user state rights. So in that sense, it might not be an effective means of managing disputes as originally envisioned, but instead might actually be a way to coercively resolve them in favor of the most powerful claimant.
Okay,
so
thank you.
That pessimism balances my optimism earlier.
Okay, wonderful. Professor Nishimoto, do you have a more optimistic view on the potential?
It's probably a little bit difficult to be optimistic with regard to the COC, and I think it's very clear that there needs to be a framework for the management of the disputes that would provide the minimum expectations in regard to the conduct of states pending the resolution of the overall South China Sea dispute. But I think one obvious point that needs to be considered is what the COC will add to the non-binding declaration of conduct, which is already exists between the ASEAN states and China. And also another issue to reflect upon is to what extent the declaration of conduct was effective in regulating the behavior of the parties in the South China Sea, and whether we can expect the same or different outcomes from a legally binding code of conduct. And I think those reflecting on those questions would tend to, I think, direct you towards the position of a pessimist, unfortunately.
Okay, thank you. And Dr. Bautista.
I also unfortunately share the pessimism of Professor Nishimoto and Professor Batongbacal. I think, if anything, if I may add, I think the only state whose behavior we're trying to regulate this code of conduct is obviously not the other parties but China's. And as Professor Nishimoto hinted at, we should reassess how the 2002 declaration has actually, prevented further escalation, and have the parties actually follow the principles and precepts upon which those declarations were founded upon. And clearly the answer to those, to my own questions, is in the negative. So I'm not very optimistic, and I think it's also because of the asymmetry. If you look at how China negotiates and the position of the parties, it's really the imbalances, the asymmetry of naval, economic, and military powers that prevent that. Plus, China's duplicity. I'm gonna be in trouble with this forum, to be honest. But the double speak that it does with the states in the region. So I'm not optimistic. Plus, I think unless we see genuine good faith and compliance with principles of international law, not just the declaration, then it will be difficult to manage the dispute, let alone resolve it.
Okay, thank you so much. Some very forthright opinions being expressed by our panelists tonight, which is fantastic. But I think now would be a good time to open the floor to questions from our Wellington-based audience. So we have 2 microphones available. Please make sure you use them so our panelists can hear you. I would appreciate if you could identify yourself by name and any institutional affiliation you might have. Now, obviously, this is a sensitive area, so I prefer to avoid lengthy statements of position. So if you could keep your questions short and to the point, I'd appreciate that. So can I? Yes.
Good afternoon, good evening. Christopher Griggs, I'm a barrister here in Wellington. As such, very committed to rule of law, but I'm going to put something to you and ask you to respond to it. The history of international law discouraging major and middle powers to give up territory that they have grabbed, a la the West Bank and Crimea, is not that great. So I put it to you that the most likely scenario is the South China Sea will be resolved by power, not by law. Do you have a response to that?
Thank you for that. The eternal question of is international law even worth it? So who would like to go first? Anyone? Jay? You're muted at the moment.
Yes, I frequently encountered that type of question and or variations of it, that power, rules, and law is irrelevant. Well, I think regardless of that statement, I think it's more a reflection of what we want, what kind of world do we want to build, no? Earlier you said that you're optimists, although I do have a dash of pessimism as well. But I think the optimism derives from our intention and our hope that we would all be making, we should all be trying to make a better world and a better international community. So I would not want to give that up despite the discouraging developments. I would still advocate always in favor of law and the rule of law, because really, especially for small countries like the Philippines and the rest of Southeast Asia, law is the only way by which they can assure that they will have a fair and equal place in the world community. So that's why it's important for us to always be working towards that ideal.
Thank you. Would either of our other panelists like to jump in briefly on that?
Well, I think the explanation was put very beautifully, and I don't think I have anything to add to that. But I think that is a really eternal question for us international lawyers when we think about territorial maritime disputes.
Thank you.
On my part, Joanna, I always believe as a lawyer and an academic in the majesty of the law. So power can be defined and unraveled in different ways, but the law in itself is powerful in its power. So I believe that might does not make it right. Plus, the majesty of the law ensures that compliance without threat or the use of force or military power. It's something that we should aspirationally at least support.
Okay, thank you. Thank you for that question. Does anyone have another question?
Thank you. Rieko Hayakawa from Doshisha University. Nishimoto です。こんにちは。Like Vanuatu, Republic of Vanuatu, a small island country in Pacific, they consistently support China's position. And also they host law school of University of South Pacific. And also they sold thousands of passports to like Chinese. How we can do this situation and how we can do for like a Vanuatu and small country? Can we, is there any possibility we can explain or whatever what we can do?
Okay, so I think the question was about China's work in the Pacific and their influence there and whether there is anything we can do to counter it. Is that right? Would anyone like to? Yes, go ahead, Jay.
Okay. Well, of course, no, it's a classic dilemma for small states, no, and how they relate with large powers. I think that Vanuatu is not alone in this problem. There are many other small states as well confronted with the same issues. And each state will have to resolve its dilemmas in their own way, in taking into account their own interests. But one thing is sure, dealing with a large power alone rarely produces a fair and equitable outcome. And so for smaller states, the hope lies in friendships, alliances, or associations with other states, no, so that they can have more power as a united group. No? The South Small Island developing states, for example, have always been among my best examples of how small, relatively powerless states could use law in order to create something that's far more powerful than them individually. Now, you have the small island developing states being able to work with other states through the Western and Central Pacific Fisheries Commission, for example, and through that entity, they're able to work or deal with other states as equals, and they're able to preserve their and protect their interests, no, and make other states deal with them as equals. So that is an example, I think, and I'm sure there are many other possible examples where through unity with other states, a lot more can be done, and a lot more power can be leveraged than what you would have alone.
Thank you. Any other comments? No? Okay. Do we have any other questions from the audience? Yes.
Kia ora katoa, Adam Stwinsky, postgrad student here at Victoria University. Moving beyond the legal aspects, but when we look at the South China Sea issue, but when we add in the China's Belt and Road Initiative, are we seeing another piece of the puzzle of China's grand strategy, and how might the SCS issue and the BRI be linked as part of an attempt for gaining regional or pan-regional homogeneity? Thank you.
were you able to hear the question okay? Yes. Who would like to, would anyone? So the question is really the link between the Belt and Road Initiative and the South China Sea. Lowell, do you have a comment to make?
I think the question is related to the previous question, and Jay's response is also appropriate. But my thoughts on that is it's really classic checkbook diplomacy, if I may be bold again to mention, and really in my opinion, I mean, you see, I hope I've not managed to demonize China in this workshop, but I think it's clear to everyone that at some point, I mean, we have, as they say, a theater of hegemonic competition happening in our backyard, and we want, China to peacefully rise, and that peaceful rise, should that we should have scope for a hegemon who is following the rules and not just bending the rules or breaking the rules or using its influence to coerce or co-opt states. So I mean, it's understandable that's how China is using that, but again, the rules of the game should not allow China, to the point of brinkmanship or to the point of breaking these rules. And it is also understandable why states would grab the opportunity for some grants or aids or loans to take China's size. But if you look at the great bulk of states, the maritime powers, those whose opinions are of great weight, you can see where the alliances actually lie. And if you take the China's incentives, you will expose and really unravel where the loyalties of these countries are.
Thank you. Professor Nishimoto, do you have any particular perspective on that?
I just wanted to thank thank you for the question, because I think it's a very relevant perspective that we have when we think about the South China Sea issues. And I agree that the situation issue of the Belt and Road Initiative, I think, is connected to the issue of the South China Sea. But at the same time, China is, of course, entitled to seek its own diplomatic and economic policy. It is entitled to seek its economic development. And of course, through its Belt and Road Initiative, it will be in a position to exert certain influence to states in the region. But I think the question is for what purpose that influence is used. And to the extent that influence is used to induce states to support its position, which is clearly inconsistent with international, then I have a problem. But overall, I think it's very important to look at the overall perspective. But at the same time, when we think about the Belt and Road Initiative issues, I think it really depends on what the influence is used for, rather than the project itself, or rather what China is doing in that field.
Thank you, Nishimoto-san. I think you make a really good point that, of course, all countries aim to exercise influence in some way or another. And, the Belt and Road Initiative is one example of China exercising its influence. Professor Batongbacal, do you want to say anything?
Yeah, yes. The BRI is indeed an interesting concept. It is undoubtedly part of China's economic strategy to address issues like overcapacity and the need to export its investments in manpower, etc. No? But when you look at it also, it's you can also view it from the classical geopolitical lens. No, it's classic Mackinder and Spickman and the bit of Mahan, and you get to understand, you gain a perspective that the BRI is also linked with its the expansion of its economy and its attempt to weave the regional, the Eurasian, if not the global economy around it, as part of its overall thrust to become a modern socialist state by 2050, in accordance with its commitments and plans and its Chinese dream. So this is all, I think, linked. And the South China Sea does play a role in this, because after all, if nothing else, it is their main gateway for maritime trade. And maritime trade is necessary for them to be able to establish the economic relations, the trade relations, and the create the lifelines, economic lifelines, by which they will be able to create, by which they'll be able to weave economies around them and turn themselves into the engine of economic growth of the Eurasian continent as well as Africa. So this is all, I'm sure, well, from my perspective, this can all be seen from that lens. And
Okay.
as Nishimoto-san said, no, the question now is, once you've done that, what do you do with it? No, to what ends will the power or influence gained by that be employed? So that is really the other question.
Thank you very much. Unfortunately, we have come to the end of our session. The conversation has been very engaging and very well informed. So thank you so much for your contributions today. I'd like to ask the audience here to join me in thanking our panelists.